Good evening. A very warm welcome to our distinguished and eminent guests, colleagues, students, and friends of Monash Law. I'm Stephen, I'm the Dean of the Faculty. It is my real pleasure to serve as your MC for this very special event. So we're gathered here to celebrate a milestone, the relaunch of one of our research centres, the Australian Centre for Justice Innovation, as the Warren Centre for Civil Justice. As we begin, I want to acknowledge the Wurundjeri people of the Kulin Nation, the traditional custodians of the unceded lands on which we meet. Tonight, in our context of civil justice, I think it is very important that we recognise that we stand on a land where a sophisticated system of law and kinship and dispute resolution has existed for tens of thousands of years. And what we're doing here is trying to work together to innovate and improve our current civil justice systems, and we do so with a deep respect for the enduring sovereignty and justice-seeking of First Nations peoples. So let me pay my respects to First Nations elders past and present and offer a very warm welcome to our First Nations guests. For many years, the ACJI has been at the heart of our faculty's research into how the law actually works, not just in books, but in the lives of people with rights and legal needs. And doing so in a space where civil justice is often the silent pillar of the legal system, and yet also the one that touches the lives of everyday Australians most directly. And when we think about the work of the ACJI in alternative dispute resolution, in court technology, in family justice, in litigants in person, in claims and claim making, so much of it through and with really careful empirical research that has already improved the experience and reality of civil justice for thousands, that impact, reducing the friction of a legal system that is itself often straining. So today, in relaunching the ACJI as the Warren Centre, we are publicly signalling our intent and our focus, this idea that an effective civil justice system is a fundamental civic necessity, and that our research here at Monash provides an empirical foundation to make access and enforcement of rights a reality for all Australians. Now, the work of a research centre like the Warren Centre serves as a necessary bridge between rigorous academic inquiry and the practical administration of justice. And at a time when the public value of higher education is under scrutiny and the sustainability of its funding is debated, we must be clear about our purpose, that a university is an essential site for the kind of independent and rigorous research that neither government nor private consultancy is positioned to undertake. That is one of the ways in which a university honours its social contract, by acting as a trusted actor for solving the most persistent challenges in our civil life. This relaunched Warren Centre bears, of course, the name of one of our most distinguished alum, the Honourable Marilyn Warren, ACKC. First woman to be Chief Justice of the Supreme Court in Victoria, her impact is defined, I think, by a relentless pursuit of a more efficient, more accessible, fairer, and technologically advanced justice system. And to have her name associated with this centre provides us with a lodestar about how we go forward with our research and with our advocacy. And I can think of no one better to begin this new chapter, no one better suited to lead the Warren Centre than its foundation director, Associate Professor Genevieve Grant, whose leadership and vision have been the primary catalysts for this transition. Somebody had suggested, and I can't remember who it was now, somebody had suggested the name the Stephen Vaughan Centre for Civil Justice, but Genevieve quickly shot that down, and so we are where we are. Genevieve is a preeminent figure in empirical legal scholarship globally, and her research has had a profound real-world impact, making the lives of thousands of people better. She truly represents the very best of our faculty, combining world-class academic excellence with an unparalleled dedication to mentoring the next generation of legal minds and to improving the quality of justice. Genevieve, over to you. Thank you.
Thank you, Stephen. Distinguished guests, colleagues, students and friends, I too would like to start by acknowledging the people of the Kulin Nations on whose land we're gathered today and to pay my respects to their elders, past and present. This evening's really a time for celebration. We're here to mark the launch of the Warren Centre for Civil Justice, a research centre that carries with it not only a new name, but also a renewed sense of purpose, ambition and possibility. Built on the foundations of the Australian Centre for Justice Innovation, which served our faculty with distinction for the last 15 years. The Warren Centre really represents the next chapter in Monash Law's commitment to understanding and improving civil justice. And what better way to begin that chapter by honouring the person whose name the centre proudly bears. Professor the Honourable Marilyn Warren, ACJI, has made a contribution to civil justice in this country that is quite simply extraordinary. As Chief Justice of the Supreme Court of Victoria for over a decade, she brought a deep and abiding commitment to a justice system that works for everyone. She championed court modernisation, access to justice, and the dignity of all of those who come before the law. It's entirely fitting that a centre dedicated to understanding and improving civil justice should carry her name, and we're enormously grateful that she agreed to our proposal to name the centre in her honour. So, what is the Warren Centre for? At its heart, our mission is to improve understanding of civil justice and to inform innovation in its processes, services, experiences, and the access that shapes people's encounters with the law. We principally do this through high-quality socio-legal and empirical research that takes seriously the lived experiences of real people navigating legal problems and the data generated in encounters with justice systems, and that translates findings into genuine impact in policy and practice. It's research that asks, when someone faces a debt problem, a housing dispute, a family breakdown or a workplace injury, can they understand their options? Can they access help? And what sort of resolution do they actually achieve? It asks how courts and tribunals are changing as they adopt digital processes, hear matters online and build new data infrastructure, and what those changes mean for the people who appear before them. And as our courts and tribunals generate ever larger volumes of data, how do we harness those resources to understand what the system is actually producing and for whom? These are examples of the kinds of questions that animate our work across 5 interconnected themes: the people of civil justice problems and processes, civil justice institutions, and enhancing access to civil justice, and the socio-legal studies framework that underpins it all. As Lynn Holtain has argued recently, we can't fix what we don't know, and the evidence is critical. So these themes really reflect our conviction that to truly understand the civil justice system, you must examine it from every angle. So we launched today not only with ambition, but also with a remarkable track record of research excellence to build on. Warren Centre researchers have secured significant grant funding from both the Australian Research Council and the National Health and Medical Research Council, 2 of Australia's most prestigious and competitive funding bodies. We have doctoral students whose work is funded by the National Health and Medical Research Council Centre for Research Excellence in recovery after compensable injury. Their research is examining critical questions about quality and costs in personal injury legal services. This year, Associate Professor Mark Trabsky concluded his ARC Fellowship on the implications of virtual autopsies in coronial investigations, and Dr Jess Mant will shortly commence her Discovery Early Career Researcher Award project on procedural justice in uneven family court hearings. These are the hearings which involve one party appearing as a self-represented litigant. We're engaged in discovery projects investigating the optimal design of online hearings and redesigning workers' compensation from the perspective of injured workers. So the funding that we've obtained through these projects has enabled us to do things that would otherwise be impossible. We support graduate research scholarships, bringing the next generation of civil justice researchers into our community. We forge highly novel collaborations across disciplines with researchers in public health, psychology, IT, health economics, and others who bring perspectives that help us to enrich and challenge our legal thinking in equal measure. This work also enables us to collaborate with community members, courts and tribunals, dispute resolution agencies, regulators, community legal centres, and legal service providers to build the evidence base on what works. This is what serious, sustained investment in empirical legal research looks like, and it's a foundation that we're immensely proud of. One of the things that really distinguishes the Warren Centre is our commitment not to just produce excellent research, but also to build capacity for that work in the law faculty and beyond it. We work with our partners to strengthen their capacity to generate, use and act on evidence. So we believe the ability to ask good research questions, to collect and analyse data rigorously and to translate findings into practice shouldn't just be confined to universities. So we also launched today at a moment of genuine consequence, always a crisis in civil justice. Civil justice in Australia is, though, at a critical juncture. The challenges are real and pressing. We know that legal need is widespread and that it's not experienced evenly, that those who face the greatest barriers to justice are often those with the most at stake. Courts and tribunals are under pressure. The costs of help and justice remain prohibitive for many. And then there's the profound disruption and opportunity of generative artificial intelligence. We know that it holds genuine promise for improving access, reducing costs, and making the system more navigable for everyday people. But it also carries real risks of entrenching disadvantage, of undermining confidence in the rule of law, of outpacing the protective regulatory and institutional frameworks. The Warren Centre will be at the forefront of understanding both sides of that ledger, bringing rigorous empirical evidence to bear on questions that matter enormously for the future of civil justice. I now want to say something about Monash Law as being the perfect home for this work. Ours is not just a law school that happens to have a research centre, though it does. We're a faculty with a deep and genuine commitment to research that advances access to justice, and we do this especially in collaboration with colleagues in our clinical legal education program. Our students don't just learn about law in the abstract, they work alongside real clients in real legal services, grappling with real civil justice problems, and this is an extraordinary asset. The Warren Centre will work in close partnership with our clinics so that research informs practice and practice will inform our research, and in which our students are active participants in the project of improving civil justice. Our students are, frankly, one of our greatest strengths. The Centre's Vacation Research Scholarship program shows what's possible when our outstanding students are given the opportunity to contribute to serious research. Our pipeline of talent, curiosity and commitment is something the Warren Centre will continue to nurture and celebrate. This semester, Dr Naomi Bursteiner and I are teaching litigation and dispute resolution, and we've had the privilege of putting the combined brain power of our 300 students to work on the task of improving the Supreme Court's new short and expedited cases list, and the results are fascinating. So to our partners in the community, in courts and tribunals, in legal centres and in government, we look forward to deepening our collaboration in the years ahead. The work of improving civil justice is not something that one part of the ecosystem can do alone. It requires exactly the kind of partnership, rigour and shared commitment that the Warren Centre is built to foster. I want to take a moment to thank my colleagues and Warren Centre Deputy Directors, Dr Jess Mant and Associate Professor Mark Trabsky for their significant work on developing our vision for the Warren Centre. I'd also like to thank Professor Stephen Vaughan, Dean of the Faculty, for his unwavering support of our plans. And to Professor the Honourable Marilyn Warren, on behalf of everyone in this room, thank you. Your legacy is woven into the fabric of civil justice in Victoria and will continue to inspire everything that our centre does. So it's now my great honour to introduce the Honourable Chief Justice Richard Nile, who's going to say a few words.
Thank you very much, Genevieve. Can I also echo the acknowledgement of country and pay my respects to the traditional owners of this land. I'm delighted personally and on behalf of the Court to mark the renaming of the Australian Centre for Justice Innovation as the Warren Centre for Civil Justice, and the launch of an exciting new chapter for the Centre. I acknowledge Professor the Honourable Marilyn Warren, ACKC, Professor Stephen Vaughan, Dean, Associate Professor Genevieve Grant, Inaugural Director of the Warren Centre, academics, judicial officers, other distinguished guests and ladies and gentlemen. Without any disrespect to her considerable achievements, I will refer to our guest of honour as Marilyn. When anyone refers to Marilyn, everyone knows exactly who is being spoken of. The name has inspired affection and respect from judges, the profession and beyond, and occasional anxiety in officials of the state. The renaming of the centre in honour of Marilyn is a fitting recognition of the significant and enduring contribution she has made to civil justice in this state, particularly in her 14 years as Chief Justice of Victoria. It adds, this acknowledgement and recognition adds to the many honours that Marilyn has received, and like those honours also reflects so well on the court that she has served. So the court is also delighted to bask in the glory of the Warren Centre. No doubt many of you are already well acquainted with Marilyn's career and achievements, but I want to touch on them briefly tonight. It's an appropriate occasion to mark them. The citation accompanying her appointment as a Companion of the Order of Australia catches some, but only some, of her remarkable achievements. The citation records that Marilyn was appointed as a Companion for service to the judiciary and to the legal profession, particularly the delivery and administration of law in Victoria, to the community in areas affecting the social and economic conditions of women, and to forensic medicine internationally. It's a remarkably broad and important area of work. Anyone who works in the Supreme Court across the road develops an acute sense of history. The building we work in has remained largely unchanged over its almost 150 years. And in many ways, our role in applying the law without fear or favour, affection or ill will remains a constant in our lives and in the life of the court and in the life of the community. And Marilyn has an especially keen appreciation of that history. Her history of the court, given in a paper, or in a conference judging for the people, recognising 175 years of the Supreme Court, repays rereading. It's an interesting account of the history of the court and its significance for the early colony and beyond. But as the 11th Chief Justice of Victoria and the first woman appointed to that office, Marilyn has always understood the importance of innovation and breaking new ground. Change and adaptation were defining characteristics of Marilyn's career from the outset. Innovation for Marilyn has never been just about who she is, but rather what she does. She's a doer. In 1974, she was the first female article clerk in the Victorian Public Service. She joined the Victorian Bar in 1985, practising in commercial and administrative law, taking silk in 1997. It's worth reminding you that the first female judge of the court was only appointed in 1996, the Honourable Rosemary Barmford. And although there are many women silks of very fine distinction at the Victorian Bar and of the bars of Australia, it was not common to have female silks in 1997. The following year, Marilyn was appointed to the Supreme Court, marking both a happy occasion of appointing female silks to the court, but also a slightly sad occasion for the loss that the bar suffers from the appointments of women so early in their career as silks. But Marilyn took to the life of a judge with great aplomb, alacrity and skill. She was judge in charge of the then Commercial and Corporations List. And, as it's been noted, she was appointed Chief Justice in 2003, the first woman to occupy that role. Not only the first female to occupy the role of the Supreme Court in Victoria, but also the first woman for any Supreme Court in this country, and internationally, for a woman to lead a court of the scale and importance of the Supreme Court of Victoria was rare indeed. Each Chief Justice, and there have been, I'm the 13th, which is a very small number for a history of over 175 years, but each of us has benefited and seeks to build on the legacy of those who've gone before. After the Honourable Anne Ferguson, I am the second Chief Justice to benefit from Marilyn's extraordinary work, which continues to permeate the influence of the court in most profound ways. Although I wasn't a judge on the court at the time Marilyn was Chief Justice, her influence continues in many, many different ways. I want to mention a couple of Marilyn's innovations. Firstly, I want to talk about leadership and impact. Marilyn was a leader for whom impact was important. Her Honour was a dynamic and highly respected leader within the court and within the profession. She had strong, and has, I should say, clear visions, and was tireless in her efforts to ensure the court delivered for the Victorian community. As Chief Justice, she cared deeply about access to justice, fairness, and the experiences of all who entered the court and those who worked within it. There is no doubt that Marilyn had a transformative effect on the court as an institution. Central to Marilyn's ethos was a clear and sophisticated appreciation of the central place that the Supreme Court and the judicial branch of this state more broadly plays as a branch of government. Within that context, independence, impartiality and judicial excellence were organising principles which she infused into the operations of the court and the judicial branch. Her Honour understood and championed the idea of independence as not being just about decisional independence, but also institutional independence. That is, it was not just about a judge being impartial and independent in a given case, but that the structures and operations, that the institution of the court was independent of the influence of the other branches of government. Central to that was the role the courts and the Chief Justice plays in the administration of the courts and the creation of an independent court agency overseen by Courts Counsel. Marilyn understood, and this was an early influence, I think, in this area, that judicial independence is a driver of innovation and excellence. Independent, impartial courts play a critical role in democracies and in the economic success and sustainability of our society. A fair, efficient and reliable civil justice system encourages innovation and investment in a virtuous circle. These considerations remain cardinal considerations for a modern, responsive and high-achieving court system, which were the attributes that Marilyn's Chief Justice strived to achieve. As Chief Justice, Marilyn Warren also understood that the judicial process is above all a human undertaking. Judges are human, they're members of the community, and the people who come before them are humans with human stories and human foibles and frailties. And it's important to have an understanding that courts are human undertakings when one considers how to make them modern and effective. At a farewell breakfast hosted by the Women Barristers Association and Victorian Women Lawyers, the Honourable Pamela Tate noted that Marilyn, quote, has been responsible practically single-handedly for the transformation of the court to a modern, efficient organisation that is welcoming to women both as judges and as lawyers. In practical terms, Marilyn was a visionary when it came to the court's digital future, striving for a paper-free court. The commercial court was established and thrived under her leadership, and she was passionate about the court's built environment. I just want to reflect on a few areas of leadership in which the influence of Marilyn Warren has been sustained, meaningful and lasting. Firstly, the creation of the commercial court. It's important, I think, to recognise on a night celebrating a centre of civil justice that we recognise the civil system of justice in all its manifestations. And as Chief Justice, Marilyn Warren understood the importance of having efficient and effective commercial dispute resolution within the Supreme Court. Her Honour oversaw the establishment in 2009 of the Commercial Court, following the Victorian Law Reform's 2008 Civil Justice Review Report. Central to that, the operation and undertaking of the Commercial Court was efficiency and reducing the costs of civil litigation, largely based on the London Commercial Court. Designed to meet the demand for specialist judicial management of a greater number of commercial disputes, the Commercial Court emphasised efficiency, flexibility and innovation, hallmarks which are relevant to all aspects of civil jurisdiction. civil justice and the civil jurisdictions, both in the courts and tribunals. It operated as a think tank for case management and trial reform, and its techniques were adopted in other parts of the court. It was also a model for significant parts of the new Civil Procedure Act. Today, our commercial court continues to facilitate the just, efficient and cost-effective resolution of large and complex disputes. It continues to adapt. The commercial court has recently added 2 new lists, an expedited cases list and a regulatory list, in recognition of the importance of timely decision-making and the increased importance of the regulatory state in commerce. These abilities to adapt and reform have largely built upon the inspiration of Chief Justice Warren in setting up the court in the first place. The advent of judicial mediation was another notable development during Marilyn's tenure. In 2005, Masters of the Court, now Associate Judges, began conducting mediations, and these mediations remain an integral aspect of modern case management. In addition to setting up a new court, the commercial court, and the importance of judicial mediation, as Chief Justice, Marilyn Warren also understood the important role that technology plays in a court system. Under her leadership, there was a significant and transformative transformation of the court, which gave effect to her vision of the court as a modern centre for innovation and excellence. During the tenure of Chief Justice Warren, the court evolved from an entirely paper-based institution, which it had been since it was established in 1852, to one that embraced and utilised technology in meaningful ways. Developing and strengthening the court's digital capability has had a particularly significant impact on large civil disputes, which are often long-running and involve huge numbers of documents. Central to this was acquiring an independent, high-quality IT system. This was not without its challenges, and navigating and implementing such significant changes required perseverance, agility, collaboration and leadership, all of which are hallmarks of the Marilyn Warren Court. It's important to record, as we now move to what's sometimes said as a new epoch in computing, that it's being built on a technology which has been, in respect of which there's been continuing investment and upskilling within the Supreme Court itself. In 2012, the Court moved to a technology strategic plan, which was a focal point for the work of the Court. In 2004, the conduct of the Kilmore East bushfire and the Great Southern Investment Scheme trials demonstrated the benefits technology could provide in large-scale litigation. Marilyn Warren noted at the time that independent analysis conducted of both trials disclosed that the trial time was reduced by about 1/3. Further, there was a very real facilitation of access to justice by the streaming of the trial. And we see in those observations of the Chief Justice that technology was not sought as an end in itself, but it was about facilitating access to justice, it was about more efficient outcomes, and it was about timeliness of hearings and their determination. The live streaming of trials and hearings in the Supreme Court remains a significant way in which it can communicate to the community the important work that it undertakes. In late 2015, the Court endorsed a digital strategy with the aim of overhauling the Court's reliance on paper and creating a modern, sophisticated system of electronic files and digitally enabled courtrooms that make it possible to hear cases electronically. At this time and during this period, Marilyn was working closely with Louise Anderson, the then CEO of the Supreme Court and the current CEO of Court Services at Victoria. Louise joins us here this evening, and she and her work was instrumental in the implementation of a standalone and sophisticated technology within the Supreme Court, which holds it in very good stead. There are other significant changes in 2017 as the Court published practice notes on technology, and in 2019 the launch of eCourt. When one looks at those innovations, the importance of them and the advanced thinking that they embodied really was demonstrated when the society and the community was blighted by COVID. The idea that many hearings would be heard online was really the idea, well, we'll have an occasional directions hearings. But the footprint and the technological innovation and investment enabled the court to really turn immediately to having hearings online during the COVID pandemic. And it was a testament to the hard work of CSV, to Louise Anderson, but also to the foresight of Marilyn when she started this process, that the court was able to adopt and adapt so quickly in a time of crisis. Technology, of course, constantly changes and evolves, but we approach the AI environment having a good footprint for which Marilyn should be thanked. It also encourages innovation and change in the mindset of judges and court staff, and it is essential that staff, judges of the Supreme Court are open to change and that they are inculcated and supported in a tech-heavy environment. And I'm pleased to say that's the case in the Supreme Court of Victoria. And the court remains committed to furthering this work and harnessing innovations. Beyond the courtroom, and as Marilyn's professorial title reveals, Marilyn Warren has also had a long and close association with the Academy, and this university in particular. Marilyn has dedicated her time since retirement from the court to legal academia and education. In 2018, she was appointed a Vice-Chancellor's Professorial Fellow of Monash, and she is a member of Monash University Global Leaders Summit. She is involved in teaching various postgraduate programs in the faculty, including advanced commercial law, international arbitration, and has co-authored a major arbitration text, International Australian Commercial Arbitration. Like Marilyn Warren, I too recognise the vital role that academics play in our legal community. The academic community is a diverse and thriving one, which includes academics, practitioners working across government, community organisations, the private sector, and members of the judiciary. It's important that all of the aspects of the legal community look to the Academy for inspiration and ideas as it continues to evolve and innovate. As academics, can I acknowledge your essential contribution through research and scholarship and your dedication to educating the next generation of legal minds. It is very fitting that this centre, which has at its vision shaping better civil justice access and outcomes through high quality and impactful research, it's very fitting that this centre is now to be named the Warren Centre. Its central mission, as Genevieve has explained, is strengthening civil justice systems to ensure that they're fair, efficient and accessible. Those features of fairness, efficiency and accessibility were a priority for Marilyn Warren as Chief Justice, and it remains a focus of those who lead the courts today. It's important that civil justice is recognised as an essential aspect of the rule of law, and that we see this rule of law not just as a criminal paradigm. The work of this newly named centre will have a tangible and real-world impact. A well-functioning civil justice system, and well-functioning in the sense that it's accessible and efficient, a well-functioning system is critical to the success of our society. A comprehensive understanding of civil justice and the dynamic challenges the system faces as our world evolves at rapid speed is the first step towards identifying evidence-based ways to improve and strengthen it. I look forward to seeing the fruits of the centre under its new name, and I have no doubt that the centre will continue to produce high-quality, impactful research in the years to come, and I can think of no better namesake than the Honourable Marilyn Warren, under which it will sail. Thank you.
Thank you, Chief Justice Niall. One of the very many lovely things about this evening is that the Honourable Professor Marilyn Warren is an alum of this law faculty. Chief Justice Niall is an alum of this law faculty, and our next speaker is also an alum of this law faculty. So I'm now very pleased indeed to introduce Justice Elizabeth Bennett of the Federal Court. I didn't know Justice Bennett very well and thought I should do some homework. So I went and read earlier today the welcome offered in February 2025 as part of the ceremonial sitting of the full Federal Court. I now know we are both great Star Trek fans, though we disagree about Voyager. We'll come to that later. But the thing that stood out to me for tonight in terms of civil justice in reading that welcome was the most wonderful story that as a teenager working in the Templestowe Safeway, Justice Bennett refused her own mother the key to the bathroom for not providing photographic identification. Justice Bennett, over to you. Thank you.
Look, rules are rules, and if I start to make exceptions for my mother, then how does that look? Anyway, sorry. I would also like to acknowledge the traditional owners of the land on which we're meeting tonight and pay my respects to their elders past and present, and to extend that respect to any First Nations people present here tonight. I'm really delighted to be here. Any gathering of my beloved alumni is a pleasure to be at, and I'm particularly grateful to be in the presence of the honoured guests that we have here tonight, Professor the Honourable Marilyn Warren in particular, Professor Stephen Vaughan, despite his failure to fully appreciate Voyager, Associate Professor Genevieve Grant, who will be a wonderful inaugural director of the Warren Centre, and academics, judicial officers and other distinguished guests. So it's a pleasure to be here with you all tonight. Chief Justice Niall will forgive me if I excuse myself from using the Honourable Professor Warren's first name tonight, and he will forgive me when he realises that I was in fact an associate at the Supreme Court while Her Honour was the Chief Justice. And it is hard to move on from that to first name bases. And in fact, as I was reflecting upon the great privilege of speaking tonight, I was taken back to a time when I was 26 years old, relatively fit and healthy, and riding my bike to work every morning. And then one morning I stopped on my ride in and realised that I was riding next to the Chief Justice. And that's a discombobulating sensation, and one is never sure of the etiquette in those situations. But that sensation quite quickly gave way to hurt pride as I was left in the dust of the Chief Justice at the bottom of the hill of that next to Carlton Gardens, as you know the one. But looking back on those times, I see some sort of analogy, because really, when you stop and think about it, in some sense, aren't we all following in the slipstream of the Honourable, the Professor Marilyn Warren? I feel like we are, and certainly when it comes to the approach to civil justice, as Chief Justice Niall has just outlined, the ways in which Her Honour led the way in innovation in relation to civil justice during her time, in ways that are still being echoed today. It has strong resonances for what the future might hold, and I wanted to reflect upon those matters by reference to an article which my associates found for me in the course of preparing for today. That is a speech written by the Honourable Marilyn Warren AC, Chief Justice of the Supreme Court, in February 2016 about the future of civil procedure. And it's so timely and a little bit odd, really, when you think about it. It's almost exactly 10 years on, we get to pause and reflect about the future that Her Honour then foresaw and the future that we now foresee. And we'll see that there's a lot of similarities, and a lot of the challenges and issues that we're now facing were embryonic at the time, but still very much foreseen. So that paper identifies, in what can only be considered a masterclass in understatement, I'm going to quote, "There will be more class actions." Now, It's fair to say that in the time since there has been an increase in the number and nature of class actions, and the issues that have arisen as that complexity, as those cases have come before the various courts, has been really varied and extensive. So, as most people in this room are no doubt already aware, one of the core rationales for class actions is access to justice. The idea that litigants have the opportunity to run cases that they would not on their own be able to run. So to take an absurdly simplified example, before class actions existed in their current form, a company didn't really need to fear overcharging customers $10 a head because nobody was ever going to sue them for the recovery of the $10. No matter how many really were affected, it just was never, until they were stopped by injunction or regulatory action, there was no cost-effective method to recover the costs or to get your money back. And so the perception for a lot of consumers was there was no effective remedy, and there could be a perception in the wake of that fact that for the company, the cost-benefit analysis did not really favour a too careful analysis of their systems and processes to identify overcharging by minimal amounts or by smallish amounts. And it's fair to say that class actions have radically shifted that cost-benefit analysis. And it has also led to the increasing professionalisation of an entire industry around funders and lawyers and barristers and insurers that are attuned to the particular processes that were even 10 years ago only still in their infancy but are now really teenagers, if I can stretch the analogy. And those have raised questions like those which were raised by the Chief Justice of my court, Chief Justice Mortimer, in a recent case of McDonald and the Commonwealth following the settlement of a class action that was run for the benefit of First Nations people. And Her Honour there said, "The pursuit of the business model has, in my respectful opinion, at times overshadowed these good intentions. It seems to me a not inconsiderable number of people in the Aboriginal and Torres Strait Islander communities in the Northern Territory would look at the figures being paid to the lawyers and to the funder, indeed even to the administrator and the costs assessor, and then look at what their family members are getting at an individual level, and they would be frustrated and likely mystified about how city-based non-Indigenous participants in this proceeding come out with so much money compared to their family and friends. I doubt they see much social justice in this outcome." Rona went on to say, "Courts need to be cautious that their protective role under Part 4A is not seen as being little more than an adjunct to considerable commercial profits being made out of litigation and on the backs of the applicants and group members." And so one can see the really difficult, complex issues that courts are being called upon to grapple with. There's no simple answer to these things. Consumers deserve to have an avenue to have their rights addressed. Courts are right to be concerned about the use of its processes for the benefit of lawyers, perhaps to the exclusion or to the minimisation of others. These are really significant issues that impact upon the perception of justice being done, the fact of justice being done, and broader social, economic and cultural pictures within which they take place all have an effect. And that is where the courts and the community can look to the Academy to help as a disinterested, impartial, and I don't mean disinterested in any sense that not interested, I mean impartial, careful, thoughtful and rigorous. All of the words used by the Dean in his introduction about where the Academy sits in our understanding of the legal processes within which we all work. There is an enormous benefit for the system and the community to be gained in grappling with these issues from people with that level of expertise, knowledge and integrity, and bringing it to these very tricky questions. And they can help guide us through this, I won't say quagmire, but it's close. And a centre like the Warren Centre is beautifully positioned to be a leader in that space. Another prediction by Her Honour Chief Justice Warren, as Her Honour then was in her paper, was that judicial control of matters would increase. And I thought this was a very interesting observation, and it caused me to reflect upon one of my favourite members of the judiciary, not really, but I did do some research about the one of the judges from the reign of Queen Elizabeth, Francis Bacon, who said that an over-speaking judge is no well-tuned cymbal. I don't know if you can tune a cymbal, but I think what he is trying to say is that judges shouldn't speak that much. And it gets picked up on, Lord Denning talks about this, that judges should be quiet. And as a barrister, I had some sympathy for that view. And as a judge, I've moved away from it a little bit more. And but it does reflect, it must be said, there is an observable trend towards intervention by the judiciary, properly in most cases, to direct cases. It's no longer really just let the parties as two pugilists have at it and we'll just decide in the ashes. We try now to make sure that things are run efficiently and fairly and in a manner that's proportionate, and it's appropriate that we do so. And there've been a range of different ways that courts have tried to grapple with the increasing time, complexity and cost in search of that fair, efficient, resolute and just determination of disputes. So we've seen in my court the rocket docket, a docket system. We've seen concise statements. We see specialised lists. We see the Commercial Court and the Supreme Court and the new evolutions and variations that Chief Justice Nile spoke about. And what we need and what we will benefit by is actual data about whether they help. Because at the moment, overwhelmingly, these are driven by the anecdotal sense of people who have had experience in running litigation, no doubt lots of experience, but anecdotal nonetheless. Their experience is, I ran this big class action once as a barrister. It went for 10 weeks and it was awful because I wasn't allowed to run a strikeout 2 years earlier. And then that person is then deeply in favour of strikeouts. And then another person says, well, concise statements are the way of the future. And we see lots of use and benefits from concise statements in cases that settle, but there's a lot more complexity that can arise in cases that turn into very difficult, hard-fought disputes. And where do we go for a broad, step-back answer? Judges only see the cases that they're in. And that's one change I've really observed since being on the bench is I no longer have the exposure to other judges' courtrooms anymore. I don't see or compare how different judges are doing things. I've only got myself, and it's a narrow sample size, to put it frankly. The N of 1 is not really a great sample size, as statisticians in the room will tell us. And so the role for a centre like this one is enormously helpful to bring a degree of empirical study and rigour to the question of, are these things helping? And I, for one, would be delighted to know if there is any measurable assistance gathered by these different innovations that courts periodically bring to bear. And as we've already heard, we've had the benefit of those studies in some instances, and courts are keen to take and learn from them and apply them. And there's enormous value to be garnered in that sense. You'd be shocked to learn that Chief Justice Warren did not in her speech mention AI, until you remember that 2016, no one was talking about AI. Such is the pace of its rise and change. But what Her Honour did say is that technology will transform the courts. And so you can see plainly that that is still playing out to this day. And again, we see in that there's been a lot of discussion about the high-profile downsides, the hallucinated cases, the increase in self-represented litigants with thousands of pages, and we read about those things in the newspapers. And the question I have is there a good side as well? Does AI have the potential to reduce the gap between large and small law firms and huge and tiny legal teams? Does it have the potential to mean that the deepest pockets don't necessarily have the greatest capacity to digest thousands and thousands of pages of complex material and put it before a court in a meaningful way? I once was trapped as an article clerk in a room for weeks and weeks, sifting through thousands of documents in a firm, and there were 4 firms in the country that had the manpower to do it, and very few firms or companies with the capacity to pay for it. And what if AI changes that landscape in a way that benefits access to justice? And what about self-represented litigants who have a sense of grievance but lack the language to express it to us in a way that we can readily engage with, in a way that, and can AI actually provide us with a link between that sense of grievance a self-represented litigant has, and an actual legal remedy. Is in the past, all we've had is the sense of, often unarticulated sense of grievance. And it's very difficult for judges to sift through that and to find to find whether that grievance actually is capable of sounding in legal effect. And I see the potential for AI to actually provide assistance to access to justice in those ways. And again, these are matters that require exploration, and they're not going to be explored by ad hoc individual cases in any of the courts, because it's just not the way we work and it's not the way we're capable of digesting information. And that's where centres like this one will have an enormous role to play. And so I think this centre is being relaunched or launched at a time of almost a perfect storm of issues facing civil justice. There's a burgeoning demand and complexity, meeting new and powerful AI tools with the potential to both increase and decrease the complexity and difficulty of civil litigation. And so it is a really exciting time for this centre to commence or to continue or to rededicate itself to its work as the Warren Centre for Civil Justice, and the potential for it to make a contribution that is as meaningful and as impactful as the person for whom it's named is very real. And so I want to congratulate everybody who has been a part of the creation of this centre, and to say just how much I and my colleagues are looking forward to the assistance that you will no doubt provide to the administration of justice, and particularly civil justice, into the future. Thank you very much.
Thank you, Justice Bennett. As your MC, I now have the great pleasure of introducing the namesake of the Warren Centre. I've been repeatedly informed by the former chief that she does not like or appreciate long introductions, and I think that speaks volumes in and of itself. And as Chief Justice Niall was talking, I was ticking off all the accolades I already had listed in my own notes for this part of tonight, and the only thing I noticed that Chief Justice Niall missed out was Her Honour's achievements as a champion squash player, which I would like put into the record. In preparing for tonight, I also read a number of the former chief's speeches that she gave while on the bench. And I just want to share with you two quotations about justice that struck me as incredibly important and impactful, both for Her Honour's commitment to justice and for what we're trying to do, have done, and will be doing as the Warren Centre. Here's the first quotation. Justice is something we seek because it embodies a foundation value for all communities, peoples, and nations. What we seek is not a range of personal preferences, but a view and analysis that best serves all of humanity. Justice is not solely about justice between the parties in a court case, it is also about justice to society. And the second, without justice, we could not celebrate a strong democratic nation. Justice must, in the end, be about the state of human experience as lived by individuals, families, groups, and nations. It cannot be divorced from discussion about what constitutes our humanity operating at its best. I now warmly welcome the Honourable Professor Marilyn Warren to the stage.
I wish to embrace the acknowledgement of First Nations peoples, and I pay my respects to their elders past, present and future, and those present this evening. I start out by asking you to notice something. My hands are free, the lectern is clear. Now let me give you a lesson. Do not change your handbag before you go out. Which is exactly what I did tonight. I thought, oh no, I won't wear the Prada, I'll take the Dior. And here we are. So my remarks will be very relaxed, bear with me. But I feel comforted in saying that because as I gaze around the room, I see so many dear colleagues and friends. Chief Justice Niall and Justice Bennett, representing Chief Justice Mortimer, the Dean, Professor Stephen Vaughan, Professor Robin Ward, Deputy Vice-Chancellor Research, and Assistant Professor Genevieve Grant, Director of the News Centre, and Your Honours and dear friends and colleagues, one and all. I am deeply, deeply honoured by the gesture of the University and the Faculty of Law in naming the centre as it has. I came here this evening wishing I could hide because there are so many more deserving people who did so much more than I have ever done and continue to do so much. But I was struck in preparing and reflecting on this evening that an institution is only as good as its whole. And I did have the fortune and benefit to be able to face a lot of challenges in my time as a judge and then as Chief Justice. But I was also blessed by the fact that I had colleagues to support me, engage with me, be creative, be innovative, and help to solve the problems. I was indeed blessed by the heads of the divisions of the court, the President of the Court of Appeal, and the principal judges. Each of them, in their own way, strove to refine and develop the work of their particular jurisdiction. And I have to say that I did sense on occasion as a Chief Justice, and Chief Justice Nile might enjoy this, there was quite a bit of competition across the court where the common law judges would want to make sure that they were striving ahead of the judges in the commercial court. And indeed, the Court of Appeal, well, they were never going to be left behind. So there is that sense in the work that I did when I was on the court that it wasn't me, it was actually the group that I was with and fortunate enough to work with. There were lots and lots of things that we did want to do, but a modern court faces a big problem in that governments by and large don't wish to spend much money on courts. Governments want courts to do what they always do, but do it with the same, if not less. The challenge then for the modern court is how to persuade those individuals in government, particularly the Treasury, as to why the court or courts should be funded for particular purposes. I tried many, many ways to talk to Treasury individuals, but I often felt that I was speaking to a brick wall. And I would come away empty-handed, and it was very, very frustrating. At one point, I was advised by the Secretary of Premier and Cabinet that what I could try doing was having the court engage consultants. That was very voguish at the time, and I think the reality was that the courts were not trusted by Treasury, but that people in Treasury, and I say this no way critically, they were used to speaking with and dealing with economists and finance people and the like, and they felt more comfortable with them. In any event, the court took the advice of the Secretary of Premier and Cabinet, and we engaged our first set of consultants. They came into the court and they looked at the systems and how we did things, and it was in fact highly beneficial. Judges, as Justice Bennett was indicating earlier, are so busy they never have time to stand back and really analyse and think about what is going on, what they are doing, what the lawyers are doing, and how it might be improved on a systemic and systematic basis. And so we had one set of consultants come in, and we did reasonably well. Then over the years, we realised, and indeed it was not just the Supreme Court, but other courts needed to bring in consultants. and they would produce very fine reports. They would engage very directly with the judges. The judges would be extremely cooperative. There was access to data, there was analysis of the data, there was engagement with judges, there were working groups. It was extremely active. Sometimes the consultants' reports were successful, sometimes less so. It would often come down to the political attractiveness of the particular proposal that the court was seeking. Or sometimes it would come down to one year we went perilously close to gaining a new Supreme Court building. We were knocked off by the Royal Children's Hospital expansion. How do you beat children's hospitals? I can't give Chief Justice Nile the answer to that proposition. But the relevance of telling you about the use of consultants, which is, I've observed, come to be extremely attractive to governments, both state and federal, is it is expensive, and it's not always the institution telling the story and providing the analysis. And sometimes there are occasions where it might be a bit slick, a bit shallow, or it may be that the consultant is unable to grasp the legal principle that underpins exactly what is trying to be conveyed. I only wish that the centre, which we celebrate this evening, had been available to me the way it is operating now under Associate Professor Grant and her colleagues. It would have been an absolute godsend to be able to turn to Associate Professor Grant and say, this is the problem, this is what we are doing over here, what is your view on the solution that we should seek? And so I personally celebrate greatly the relaunch of this centre, its capacity and the work it will do, the potential and the opportunity it provides. In addition, I am in the unique position that I can probably give you a personal guarantee that you will get the quality of work that you would like to receive from the centre. The reason being that in my time associated with Monash, the Vice-Chancellor has required centre reviews to be conducted, and I have in fact been involved in working parties conducting centre reviews, including the centre we celebrate this evening. And I am able to say that I have first-hand knowledge, having conducted my assessment together with the others on the working parties, 5 years apart, twice over, that the centre is first-rate, 5-star, and it's ready and waiting to take on the sort of research that we need in our justice system. But at the end of the day, as we look across the room, by and large, I think we are wall-to-wall lawyers. Forgive me if there is somebody here, Professor Ward perhaps, that does not fall into that category. And what I want to suggest to you is that each and every day, whatever we are doing, whether it is as a student, doing some of the clinical work or some of the other work that Associate Professor Grant has referred to with her students, studying self-represented litigants. What a marvellous thing for you to study. As I look across the room at academic colleagues and as I see judicial colleagues, past and present, I look at you all and I think there is one thing we are all endeavouring to do in our own way, and that is to deliver justice. Barristers do it by standing up in court, preparing and running their cases. Instructing lawyers do it by instructing the barristers. Judges do their part by hearing the cases, weighing the evidence, deciding the case, and then writing the judgment. And so it is a system that we all play a part in, day out, year in, year out. But at the end of the day, what we are endeavouring to do is to deliver justice to all. I do firmly believe the centre, in its revised form, will be a magnificent contributor to that system of justice, and it will be, Dean, another jewel in the crown of the Faculty of Law. Thank you very much, everyone, for coming this evening.
Thank you so very much. I'm going to offer a few brief words as we bring this part of our celebration to a close. Many people think the life of a dean is lunches and launches. Sadly, that is not the case, and most of my life is problems of parking and plebiscites and plumbing. But when we get to have a moment like this evening, which is a truly special celebratory moment, it is a thing of joy. What we've been able to do tonight is to reflect on the 15 years of contribution of the ACJI, a contribution that has made that difference to thousands of people, that has improved the quality of justice. When we get to think about our ambition, as Genevieve framed it, for the future and where we are going, and when we get to do all of that through celebrating, recognising and honouring one of our own, gosh, what a way to end a Wednesday. Since I joined Monash Law 15 months ago, Her Honour Professor Warren has been so very kind and so very welcoming. She is an exceptional friend of this faculty and an exceptional friend of justice. And I am so pleased that we are naming the ACJI in her honour. We move now to drinks and to nibbles. Let me encourage you, when you have a glass in your hand, to raise a toast to the new Warren Centre for Civil Justice. Thank you, everybody.